Good morning. Welcome to the Light on Suitability podcast. I'm your host, Elizabeth Comeau. I'm with my friend, co host, colleague, Joe Haytas, author extraordinaire of the 36 Strategies of Suitability. Today, we're working on strategy something. I forgot the number actually, and it's all about your parole hearing
16.
rights. 17. Wow, we're really
No,
making our way
16.
through. 16, not quite halfway. Strategy 16. It's all about your hearing rights.
That's right.
And
An important part of the hearing.
tell me about that. I was curious about that. I wanted to know why you included it. Let's just kickstart everything. Why did you include this as a strategy?
Because, you got to know what's going on. You got to know your rights. And if you have any question about those rights, then you can ask your attorney or some other trusted source of information. Like, if you didn't know that it was a right that you could submit documents, you might not submit any,
Okay. And that's all explained in your rights?
Yes. That well, I don't know if it's all explained, but it's a one of the code of regulations, or one of the more so than that, it's a also a policy of the CDCR that inmates can, incarcerated persons can submit documents.
Okay.
And they have a right to an attorney, and they have a right to a hearing 1 year before their minimum eligible parole date, etc.
Right. And so how does this affect their, is it affecting their, chances of suitability to be found suitable?
Well, it's part of the equation. It's part of their participation in the hearing, and they should be aware of everything, that's going on around them, whether it's something legal or something else. They need to know the procedure, how the hearing proceeds, and also in preparing for the hearing, what they just should be aware of, and even after the hearing, because they have a right to get a transcript of the hearing. 30 days after the hearing, it's usually available. So what if they didn't know that right? Then they may just go on and on without the knowledge that they're entitled to a transcript if for some reason their counselor doesn't give them one. Surprise. So yeah, it's important that they know them, of course, and that they have a right to be personally present and speak. Now, maybe
Right.
that might seem obvious, but historically, my understanding is that wasn't always the case. Back whenever in the 90s, 80s, 70s, as things evolved. So,
I have this little cheat sheet that I used to use.
yeah.
I'm just going to get it. Sorry. I got like the racket here with the guinea hen and everything else going on today. When I used to interview my clients, I had you won't be able to see it, but
Mm-hmm.
I don't know where my screen is now. I've lost my screen. Here it is. I used to have this. Let me see if I can get it up there. I don't think I can. I got this stupid screen on here. Oh, here it is. No, I can't. I can't do it, and it doesn't matter. But I used to go, because when I was new, I used to go and man, you guys are a pain in the butt today. Okay. So when I was new, I had the old version. Remember, it was 2 pages.
Mm-hmm.
And then I had all these notes, and I would go through all the notes with my client, and I would literally use it as kind of a format for my meeting with them to make sure everything was covered. And then I would use the rights, and I would talk about it in the context of how they could, what they're needed to be thinking about in terms of the questions coming and the preparation needed. So a lot of times too, it was to head off the questions about, there's always that state appointed attorneys don't care and this and that. So I'd go
Mm-hmm.
through that right. I'd say, the right to an attorney, that attorney has to be just as invested in your case as any private attorney. The only difference between, I would explain, having the state appointed and one of the main differences is state appointed and a private is that with a private attorney, I have a lot going on in the farm today. I don't know
Okay.
why, but that's why I'm distracted, and I apologize.
No,
But
no, no, that's
is
okay. We can just expedite this process, you know?
no, I'm no, it's fine. This goes
Mhm.
on all day long. It's always like this. Um,
Okay,
it's just my husband's not here, so I don't have that extra buffer that I usually have. So,
sure.
is like flying economy versus business class versus first class, depending on what you're getting. So, we're all flying to the same destination. If you hire a private lawyer, it's first class.
Right.
Okay.
Uh-huh.
Maybe more meetings, maybe more of that hand holding that our clients do appreciate, maybe more, of this and that. But we all have to give each client the same advice, counsel, and whatever is needed to get ready, but
Yeah.
it's all based on competence. And so because
Mhm.
they would come in and say, oh, well, I'm gonna, this, that, and the next thing about state appointed, but we all have to know the same thing and do the same things.
I love that
And
analogy. So, what, first class coach, and what was the third one?
just, basically, first class versus economy.
Oh, okay. Sure.
Okay. And sometimes in economy, you're going to get an upgrade, right? Because you're going to get the lawyer that's going to give you more of a first class or business class feel, right? They're going to not just come that this was in the day when you just had to see them 45 days before.
Uh, right. And one time, I believe.
One time, 45 days before, it could be 5 minutes, you've done your job. So in
Wait.
both,
Oh, that's right. It evolved. You could see him for any length of time,
yep.
and it evolved to an
When
hour
I
meeting.
started,
Hmm.
there were some
That's right.
attorneys that would go in and spend 15 minutes, check the box, done. And the other thing that you would do is you would not entertain waivers. Okay. You would wait. Some of these attorneys would do that. You would wait to get to the hearing and then stipulate because then you got your extra $200 or whatever. And I'm just being full transparency about
Oh,
what used to
yeah. No,
happen.
I remember that. I remember
And
those
that's
days.
why the board came in and cleaned it all up.
Hmm.
Okay. And they have added a lot more criteria. In fact, state appointed lawyers meet with their clients minimum 3 times. You don't necessarily have that with private attorneys anymore. Some of these private attorneys still, and I'm not bad mouthing anybody. It's just
No.
they still just offer one meeting. It's a lengthier meeting and the hearing is all in one fee. And then you pay extra for extra meetings. So that is an important decision. You also have the right to waive an attorney. I don't think it's a good idea, even if you get one, even if you get the true economy class attorney, that's
Hmm.
just going to do the bare minimum permitted. And you can get most of what you need from those. But it's always nice to have the attorney that's going to go the extra mile, that's going to give you the mock trials, and the attorney that's willing to tell you not necessarily what you want to hear, maybe what you need to hear, or some important information that's going to get you you're in the end zone, not the end zone, you're in the striking distance of scoring the
The red
touchdown or
zone.
whatever
Yeah,
that is.
the red zone.
Red zone. So
From
you're
the
close.
20-yard line to the goal line.
There you go. So you're close, right? And you want that attorney that's going to give you that little thing, that tip, the play that's going to get you into the end zone, right? Okay.
Yes, that's a great
Um,
analogy. Yeah.
I love my analogies today. So the other misconception was this right to attorney was, because you want to clear out that attitude of, oh, I've
Hmm.
got the state appointed, I'm going to be done wrong by this person. But you've
Yeah.
got to go and understand that our role is to not get you suitable. It's your loved one's job to get them suitable, but our job is to let them know and give them that feedback as to, well, are you doing the things that you need? Here's some other things that you need to do. Here's some other things that you need to consider. Have you thought about this question that's coming your way? Those
Hmm.
are really important things. So I used to use the right to an attorney as a really lengthy discussion with them.
Hmm.
And so I would go through, and I also would describe all the Title 15 factors to them back in the day as to, this is what they're looking for, because the client said, well, why do I have to talk about, you know, why do I have to talk about my past? Why do I have to talk about this misdemeanor that I committed in 1979? It's because, the California Supreme Court said so. And why did they do that? Because they said the commissioners and the Board of Parole hearings were violating the rights of people by denying solely on the basis of the life crime, which they did. And Joe was around in those days for a minute. He was, when they would just deny parole. I don't know if you were you there before Marcy's Law?
I came in doing it full time right around the time that Marcy Laws was came into effect. I started in 2009, and I think that was like one of the last years before. I think that actually in November of 09, if I'm not, if I'm correct, is when that was on the ballot, and then I think it became law after January 1st of 2010.
Okay, so you might not have done. So back in the day, the attorneys were doing 15 clients a week. The
Mhm.
hearings were less than an hour, and the commissioners denied 99% of the
Oh yeah,
people based on crime alone.
yeah, and
So
I've heard a lot of stories, especially back then, of that happening. Correct. Hmm. And life meant life, by the way.
life meant life. Like Mike said, you're not leaving. Governor David said, you're not going home
Right.
other than in a pine box. And so the
Mm.
California Supreme Court said in a couple of very pivotal cases that the board had been violating their own Title 15 factors by doing that, and said you cannot deny solely on the basis of the crime. And here's what you also need to consider based on your own Title 15 factors, which are, okay, the attitude, your past and present mental state, your past and present mental attitude toward the crime. So apologies. I've got a puppy that's looking around and not where he's supposed to.
Oh,
And so very important. So clients will say, why do I have to talk about this? Because the Supreme Court, and I call it a type of a bargain. They said, stop denying parole solely based on the life crime. But by the way, eligible parolees, you're going to, by the way, we're not allowed to use parolee anymore, but I don't know what the word is now, but they think it's, labeling, but I'm like, isn't everything a label? I guess it's just in how you take it, but that is coming. I don't know what the word is. Eligible
okay.
parolee, not allowed to say supervised person or something. So
Well,
more adjustments.
okay.
Okay.
So does that
So
mean a parole agent will be a supervised adjustment person?
I don't know. I really, I can't keep track at this point.
Yeah,
I'm
I need a
trying.
dictionary.
I am trying to. It's just we need to add words, but maybe we can just use acronyms. So
Okay.
the eligible parolee was, why did they I don't know where I was going. I got off track of my little.
I'm sorry, I interrupted you there. We were
No,
talking
no.
about the past and how everything's changing, and you're
Well,
t
the Supreme Court made a bargain and they
yeah,
said, your Title 15 factors, they say this stuff. So that's why you have to do this stuff, is because you actually have been given an opportunity. And this is what the Supreme Court said is permitted to be asked and considered. And that's why we have then that all of a sudden insight. That was a termed insight. Now we call it self-awareness. So uh, that's another reason why I would go through the Title 15 factors with them, which is the other part of, like Joe started this conversation with, right to an attorney. What do you do with an attorney? Use him or her to explain your rights to you. What are your rights? Title 15 factors. Now structured decision-making factors. Not exactly, regulated, but whatever. They decided to make these guidelines, which they are allowed to do under administrative law in a way, but they've kind of changed. They kind of morph away from getting far afield of the Title 15 factors in some cases. The other thing is to help them understand, some of the language used at the hearings, like what does it really mean not to retry a case? It's not what people think. It's not what people think. It's not retrying the case means if I hear all the evidence, I don't have any authority or jurisdiction to change your convictions. I don't have an authority to change your abstract of judgment. It doesn't mean what the majority of people think it means, which the majority of people, commissioners included, think it means, oh, we're not here to retry the case. We're here to hear if you're going to regurgitate what's in the probation officer's report. And that's not what that means at all. And people misapprehend that all the time, because otherwise it nullifies Penal Code 5011 and other cases of the Supreme Court and other jurisdictions that say you don't have to admit guilt to be found suitable for parole, and you don't have to agree with the official version to be found suitable for parole. And there's certain conditions on that. So that all needs to be explained by a competent lawyer who's going to protect your rights in that way. Now, our job is to give benefit of the doubt. If that doesn't seem plausible, or if that's just not going to fly, the other thing is to tell them, I can't advise you to lie on the stand. Well, it's not a
exactly.
stand,
Yeah.
but I can't advise you to lie. I can't just regurgitate the probation officer's report. That's not really a lie, but you're not going to be your most authentic self. And I've had people really burned by doing that. The other important thing is the right to an attorney. Why this is such an important strategy. Ultimately, this notice of rights chapter is, you have a right to an attorney because the inmates on the yard don't know what they're talking about. The counselors that you have are not lawyers. They don't generally know what they're doing when they're having you filling out paperwork for postponements and telling you this, that, and the next thing about your case and your hearing and your rights and how to approach it. They don't know what they're talking about. So you just need to be careful. And that's not out of disrespect. They just don't know. It's like me telling you about what the officer's role is, or how an RVR hearing process runs, or what their
Hmm.
department of, CDCR, their own guidelines and regulations. I don't have that kind of thing. I also tell them, we're not here to file habeases, help you with 602 processes, undo confidential information, none of that. We're not here to change the rules. It's like I had a client argue with me last week and got very upset, and his true colors really showed themselves as someone who wasn't suitable for parole, because when he asked me, what do you think my chances are? Unfortunately, I told him the truth, and that is based on 2 write-ups, even if they're minor, last year or within a couple of years of your hearing, in particular after any last board action, your chances have gone down considerably and unlikely to be found suitable. And if you are found suitable, it's going to be tricky to get past the governor's review. So, that's another thing is deciding when you have this attorney, do you want the truth or do you just want to be told what you want to hear and go into this hearing thinking you're going to be granted parole when you have write-ups? Okay, write-ups, recent write-ups. And the word recent is not last month. The word recent is within 3 to 5 years of your hearing. So all
Yes.
of this is under I'm kind of putting it under this big umbrella of having an attorney. And why is this? But also understanding that it's your right, you have an attorney, but all decisions are made by the eligible parolee sitting in that chair, all of them. Not your right to waive, not your right to stipulate, not your right to testify or not testify, or how much to testify about, or what to say in response to questions. Ultimately, we're here to give you counsel, guidance, answer questions, see how you might hold up and so forth. But the ultimate decision is to be made by the attorney. Now, there's a place on the form where we can just waive someone's rights without their signature. I think it's violative of state bar professional rules of conduct. I don't think we can do it. And there's other United States Supreme Court cases that say absolutely no freaking way. And another thing is, we cannot, if they don't, if you the client, your loved one, want us to advocate for suitability and say you're suitable for parole, then that's what we argue in our closing statement. That's the United States Supreme Court has been very clear on that. And that's in cases you can't concede guilt. So you need to be really careful when if you want your lawyer to do this, if you want the lawyer to say that, just remember that the lawyer can and does sometimes, that will be deemed a lack of credibility in some cases by the commissioners because they're not lawyers and they don't understand the cases. And it can be a fine line. You might prefer, if you know you're going to be found unsuitable, ask your lawyer to ask for a minimal parole date or just argue so much mitigation. But the way I get around that so everybody gets the same consideration by me is to just say, you're right. Another right that you have is to walk into that hearing. You walk in with a presumption of suitability, like all things being equal, you would have to be granted parole. Not quite analogous to when you sit down at a trial and you're not guilty. You're not guilty. When you start that trial, you're not guilty until the prosecutor does and puts on a bunch of evidence that will hold up with a jury that could say, I just can't get beyond that, right? Beyond a reasonable doubt. There's no way I would ever think that this is anything other than not guilty or guilty. I'm sorry. It's similar to that, not quite similar, but the evidence that has to come forward is the commissioners draw out evidence to support a finding, the presumption of that suitability. And oftentimes they also draw out the things that counteract that suitability. So they call it, aggravating versus mitigating. So that's, again, another right that you have is the presumption of suitability. So what you want to do is you want to constantly, your loved one wants to constantly holding that line. I'm presumed suitable unless this negative thing happens, this negative thing happens, or this other thing doesn't happen, meaning I don't continue to participate in self-help, or I continue with gang involvement, or I do whatever it is. So that's also extremely important. But some of these guys don't understand. I used to also always explain that, well, I've done 25 years, but it's 25 to life. And to life means you've got to meet the suitability criteria. Meaning you have to you're presumed suitable, and then you have to, how do you hold that suitability? The suitability factors are all in place. Okay, Title 15, and the unsuitability factors are overcome in some way. Typically, they're static, they can't change, and you've done enough work, sufficient work. It's called a lengthy and positive period of rehabilitation to uphold that. So if you just powered through discipline free for a year and a bunch of courses and self-helps, as much insight as you may have, they're going to give you credit for some rehabilitation, but not a lengthy period of rehabilitation, because what they will ask you is, well, 30 years in, and we've got 2 years of positive rehabilitation. What do
Yeah.
you think, inmate so-and-so? Do you think that's a lengthy period of positive rehabilitation? I don't know, 2 out of 20, usually 2 out of 30, usually not, usually not. And then the other important thing is to have this lawyer give you like that fair assessment is the waivers, stipulations, and postponements, and really explaining
Yeah.
what those things mean and
Yeah.
why those things are important. And really, flow charting whether or not one of those things is important. The other thing that I explain is it's not how soon can we get to a hearing, but how soon can we get you out the door? Okay. And those things that may
Conflict.
not only that, but like a waiver may get you out the door sooner, but in some cases, going to your hearing and getting a 5-year denial may actually get you out the door sooner, because a waiver sometimes adds to denial length. Sometimes you need that hearing to get going on your journey. And so the
Yeah.
commissioners don't like it, but they're not seeing it in that way. They're seeing it as, how can I get this hearing off my calendar right now? But sometimes they just need that hearing. Unfortunately, now too, these hearings have been truncated, that you don't even get the full hearing. You don't even get the full flavor of everything, because if you've got a write-up, some of these commissioners are just focusing on the write-up and moving on. Your hearing's done in 30 minutes now. So
Absolutely. And by the
I
way,
don't know. Yeah,
the
go.
incarcerated person says, well, gosh, why did I submit all those transitional plans when they didn't even talk about it, not even once, or anything like that? They just cut pretty much from talking about the discipline to, okay, counsel, do you have any follow-up questions?
Well,
You
and in
know?
that case, I think the documents are important. One, because they are required to review them. And so it's good mitigation. And so then anything your attorney can do to help mitigate your loved one's issues, there's not a lot. If you've got a write-up last year for fighting the guy in the day room, there's just not a lot that can be done other than mitigate. Full parole plans, continue to program since that fight. You take more anger management, you take more of what you need. And showing, I've got relapse prevention plans, showing that you do understand triggers. You just didn't use the coping strategies that day. Perhaps put a writing in explaining your insight behind all of that, and address it that way, because they do have to consider that. Okay. And it can help you mitigate. So if you're a complete jerk, you're going to be pushing 7-year denial if you're a jerk. And sometimes they will test you to see, okay, is it just this write up just went kind of haywire on you, or are you just still extremely antisocial and narcissistic and just not getting it?
Mm-hmm.
Okay. And so in general, some people are just not getting it. And some people, unfortunately, get into a situation where they just can't get out of it. And then fortunately, there's cameras at some of these prisons. And so some of these cameras I've noticed have been extremely helpful to my clients in having things undone. But I've been going on and on. Sorry, Joe. I kind of hijacked everything.
No,
I
no,
noticed my
you're doing
notes.
great.
So
You're doing
my
great.
note that I had, I don't know if you
Hmm.
can see it. You can
Yeah,
see the big Post-it note. I had all these
mhm.
notes. So I took this and I made it into like, how could we really use this to help them figure out how to navigate this parole hearing and the parole process. But you do have the opportunity to present documents, and I do think it's important. And I don't still parole planning. I just think it's extremely important. Unless you have developmental disabilities, a low TABE, English as a second language, mental health issues, or whatever, I would prepare parole plans and I would get transitional housing to someplace that you want to go to, because it just shows a pro-social person really thinking about his life on parole and not just leaving it to chance. I don't think that advice of not doing it is good.
Absolutely. And that's probably one of the things that got them to prison. They weren't thinking about the future. They weren't planning ahead. They were only living for this moment to be accepted by their homies or whatever they did, whatever their character defects were. It doesn't necessarily have to do with gangs. It can have to do with other things. However, they weren't thinking about the future. I mean, the consequences, first of all, about what they were doing, and something inside of them compelled them to do it, despite the fact that they know what they were doing was extremely wrong, unlawful, could get them to prison, and they are in prison now. So you can't have that same mindset about the future now. You got to be planning. You got to be thinking about how you're going to work, make earn a living wage, where you're going to be living, what kind of transportation you're going to have. Even if you don't have them nailed down, at least you're thinking about it and planning ahead. And I believe that will rid us of the nexus to the life crime. Because they always talk about in the structured decision making framework how if you're not if you're found aggravating on parole plans, that's a nexus to the crime or your past conduct. So if they don't check that box off, that's another strike against you. And you already start in the hole with the two structured decision making frameworks, the static factors. I mean, you're already in the hole there. So uh, I agree with you about parole plans. You gotta. They may not be set in stone, but you got to be working towards what you're going to be doing once you get out. Otherwise, you're going to revert back to your old habits, the things that came easy, that you feel comfortable doing, and that's not going to end up in a good result.
That's right. And these some of these parole rights are self-explanatory to the majority of our clients. But
Mm-hmm.
really, when the form comes around and your loved one gets the form, remind them, read the form. Even if the officer says, just sign here, just sign, just sign, just sign. Okay, fine, sign it. But take it and look at it and really come to your meeting prepared to talk about the stuff in this form with your attorney, because Joe mentioned you have a right to a a copy of the decision, and also you're going to get a transcript of, that's another right you have, is to receive a transcript of your hearing. Okay, I have that right. So what? No, not so what. You need to go through your transcript. The reason you have a right to a transcript is because by law, you have a right to go through that transcript. And if you see any errors in the transcription, you need to correct those, number one. But you also need to use that transcript to go, okay, what questions, if you get denied, what
Mm-hmm.
questions were asked? Where did I go right? Where did it go kind of wrong? What didn't I know? What do I need to to use to do better? It's a notice and opportunity to be heard, right? There's your
Yes.
notice. You've got it now in writing, and you can use that as a template for the next year or two to get it, to do more work and to come back. So all these rights are really tied so much to preparation. And, I wasn't asking Joe at the beginning, like, why'd you include this chapter? Because it's not important. It was just a lead into, it's extremely important to understand your rights so you know what you're doing. Are you prepared? Are you not prepared? If you do a waiver for a year, is that really gonna, that waiver, if that waiver is really gonna help you get into the, Joe calls it red zone, take it, do it, because you're going to be looking at, maybe you're looking at, and my clients never, the clients just don't, they still think impulsively. So if you come in and get a 3-year denial, let's say everything else being equal, you come back in a year and a half versus taking a year, okay? You're going to be back in a year, not a year and a half. And they don't see it. They just can't get out of their own way and take the year to finish the programming that they need. Okay? No, they want their hearing and they're forgetting. They're just not, I don't know what the word is, but they're just not listening. Basically, they're not
Yeah.
listening. And that just shows to me a lot
Mhm.
of antisocial personality disorder. Now, if because you're just not thinking about the consequences of the actions, you're thinking impulsively. You just want the hearing. And remember,
That's
it's
what I
not
was going
about
to say. Impulsively, yeah, you hit the nail on the
not
head.
about getting to the hearing. It's about getting home. So do you
Mhm.
want to take, you're going to use 6 months. That's another 6 months that you're adding to your stuff because you can't just come in there and power through a such and so class in 4 months because the commissioners are going to say not sufficient amount of time.
Mhm.
You just took one anger management class 4 months before your hearing to finish up that gap. Not enough time. They call it either sufficient dosage or sufficient time. So, and they're allowed to lengthy period, positive rehabilitation. So, and that's the Supreme Court.
Yeah, and directly addressing your past character defects and causative factors. And you
Right.
know what? That's an important point about impulsivity. I don't want to get off track here,
No, it's all
but
right.
they can be impulsive in many other ways. I tell them when you're answering questions, let the commissioner finish the question first. And when they don't, when they start their answer before the question's done, right there, I mean, on some level, even if it's subliminal, that says to the commissioner you're still impulsive.
Yeah, and you're still antisocial, disregard for the rights and not respecting another person's boundaries, right? And not listening
Yeah.
to the direction of the commissioner, saying, please, nobody talk over each other, and you're just not
Mhm.
listening. And if you can't listen to that simple instruction, are you going to listen to your parole agent? Maybe
Well,
not.
but in deference to the incarcerated person, they're nervous.
Mhm.
This isn't something that happens every day, and their freedom's on the line. So that's why they got to really know it, not just tell them maybe practice or whatever.
Right. Just practice pausing.
Hmm.
And some of this stuff I've seen, oh, well, we were pausing between answers. It's like sometimes some of these commissioners you just can't win. They have their own personality issues going on, which is fine. We're all different, but
Yeah,
I'm not.
some of them do have their personality issues, but we won't mention any names.
'Cause I don't have any maladaptive personality traits, so
Sure. Of
yeah. But
course
I'm
not.
just
None of it. Yeah.
none of us do. But
On this
yeah,
side of the table, we always were, that's why I believe it's wrong to always point your fingers at them because there's three fingers pointing back at us,
I know it's terrible.
Yeah.
Instead of looking at the stick in the other person's eye, remove the log from your own. And I
Yeah,
am
we're all human
really,
beings, we
yeah,
all fall short, and if we all got to work, no matter who we are, whether we're incarcerated or we have a shingle up in our office, we all, we go through this life, we all got to work on things.
well, some of us do, and narcissists don't. But anyway, that's my I've been focusing on narcissism. I'm learning a lot about narcissism, and I'm
Wow.
learning that there's a lot of narcissistic personality people out there, which is interesting. But
Yeah.
I'm also I discovered, and then we'll wrap it up and I'll cut you loose early since Mike isn't here to add flavor to this. The commissioners ask a lot of questions about trauma these days,
Hmm.
and how people have healed from trauma. You don't heal from trauma by addressing the trauma that you created onto somebody else. That's the programming that you do to do the anger management and to tackle your own character defects, but to handle your own trauma, you being the victim of poor parenting generally is where this all stems from. And that's a hard pill to swallow for most people, which is probably why most people don't tune into this show. But to take a hard look at ourselves is
Yeah.
always difficult. But healing your own trauma, and I'll tell you, I think an underserved or under offered program or programs that would be pivotal to understanding all this would be adult children of alcoholics and or dysfunctional families anonymous. So ACA.
Hey,
That ACA really needs to be brought to the prisons and
can you repeat
taught.
that? Did you say ATA?
Adult children of alcoholic parents and or dysfunctional families. It's all learning about how to heal from those traumas. You still work on character defects of your own, but it also helps you to identify where this all started. And so it also could help you with insight. And I really think I had a pastor reach out to me from Pleasant Valley. He wants me to come in and collaborate with him on some programming over there.
Great.
And I'm thinking he's gone for this month. I think he's coming back next month, but I'm thinking of bringing that idea to him because he asked me for some ideas. And I'm thinking of bringing that 12 step and making it that 12-step program because I think it would be really key. And I think also running these programs properly, running a proper AA and a meeting would be necessary, and also helping my clients understand that go, well, all these people want to do is just talk about their drinking. I go, yeah, but that is what you do in these meetings at the beginning. And when you start getting into recovery, then is when you start, because experience, what's my experience? How can I tell you to have hope and strength unless I have the experience? I'm
Mhm.
experienced. I went through alcoholism. I can tell you
Mm.
about the negative character traits that it brings about and all the unmanageability and all of this and that. And now I can bring to you the strength behind it and the hope that there is hope and strength. I was there and now I'm here. You were there and you could also be here if you work it. So
Mhm.
I think it's something I'm thinking about now a lot. I also think there's a ton of codependency that's going on in these prisons, and before coming to prison that creates problems and some other issues. Also, people having to deal with narcissistic personality disordered parents is probably huge, and a huge underestimation of what's happening to people before coming to prison and why there's so much trauma and childhood wounds, because it is true, unaddressed trauma is going to result in some negative coping strategy, and you're going to end up with an addiction of some kind or a disorder of some kind that needs to be addressed. And I think there's a lot of power there for everybody and these clients. And if we can get that started, what have you gotten into now? Huh?
Very well put, Elizabeth, with that. And off the record, that program. Thank you for telling me about that. I'll hopefully we'll be talking about that more in the future.
I got their book as well, and I'm looking at this book saying this is a powerful qualifying group
Hmm.
that could be well received by commissioners, as far as I'm giving you credit for what have you done, what work have you done, um, instead of just AA, because AA NA is good. It's good, but it's
Mhm.
just it doesn't get to the deeper layers.
Okay.
Okay? It can
Yeah.
help you stay on the path, but there's a layer before that. There's a reason why you're an alcoholic, and it's probably because of being an adult, a child being raised in an alcoholic or dysfunctional family of some sort, either with alcoholics or with narcissistic parents, of some disordered parents, typically narcissism or some other highly dysfunctional communicative pattern, being devalued, invalidating feelings, the gaslighting, the scapegoating that goes on in families and all that stuff. So,
Sure.
um, really, really, actually, order the book, Joe. You can get a used one on Amazon, like $6, $9 or whatever. Or get it from their own website to be supportive of their efforts.
Well,
But it's
what's
really
what's the title of the book?
adult children of alcoholics.
Oh, yeah? Okay.
It's a red book. So the AA has the big book, CODA has the
Mhm.
blue book, ACA has the red book. I think there's also Al-Anon if you're presently living with someone who's an alcoholic or dysfunctional. That's ongoing.
Mhm.
That could be good for a prisoner too. It's all about you can't change someone else to make your life better. You're going to have to change yourself. So,
Well said. Yes. Mhm.
very difficult lesson, especially if you live with people that are not functioning. They're dysfunctional.
Mhm.
And
Yeah,
you're just
absolutely.
constantly getting them to try and change, try and be better, try and communicate better. It just doesn't work. Doesn't work.
Yeah.
I'm going to end the podcast with
Yes.
asking anybody who listens through the week, please most importantly, share, comment. I would love comments. I know I have a few viewers. Comments would be wonderful. And see you next week. I don't know what the next chapter is.
Yeah, just before that, I just want to say you can get the book 36 Strategies of Suitability at Amazon.com. And or if you want to send it to your loved one at the prison, it has to come from an approved vendor. And that's why I say get it at Amazon.com. And to answer your question,
Mhm.
the next one is about a C-file review, or Olson review as it's known. And that's another part of preparation. And by the way, that's another legal right as well.
That's
Uh,
right.
yeah.
That's
So
right.
next week, chapter 17, strategy 17, rather, C-file, Olson
Mhm.
review, and document review.
Yes, and I'll try and remember to ask Marielle to add the link for your book in the show notes next time.
Oh,
I'm
great.
going to do that right now
Mm-hmm.
because, like Mike said, it was a really great book.
All right. Thank you.
I'm doing that right now. Okay, Joe, hang on the line for a second, and we can talk
Okay.
about ACA briefly, and then I'll cut you loose
All right.
and
Excellent.
stream.
Thank you.
Have a wonderful day, everybody.